24th. If we could have our opening comments, please.
Before we begin the agenda, the Wichita-Sedgwick County Metropolitan Area Planning Commission and the Wichita-Sedgwick County Board of Zoning Appeals would like to take this opportunity to welcome everyone to this public hearing. Copies of the agenda for today's meeting, the public hearing procedure, and Planning Department staff reports on all agenda items are available in the lobby of this conference room. The Planning Commission's and the BZA's bylaws limit the applicant on a zoning, subdivision, or variance application and his or her representative to a total of 10 minutes of speaking time at the start of the hearing on that item, plus up to 2 minutes at the conclusion of that hearing. All other persons wishing to speak on agenda items are limited to 3 minutes per person. However, if they feel that it is needed and justified, the chairman may extend these times by up to 2 minutes. All speakers are requested to state his or her name and address for the record when beginning to speak. When you are finished speaking, please write your name, address, and the case number on the sheet provided in the lobby. This will enable staff to notify you if there are any additional proceedings concerning that item. Please note that all written and visual materials you present to the Commission and the Board will be retained by the Secretary as part of the official record. If you are not speaking but you wish to be notified about future proceedings on a particular case, please sign in on that same sheet. The Planning Commission and the Board are interested in hearing the views of all persons who wish to express themselves on the agenda items. However, we ask that all speakers please be as concise as possible and avoid long repetitions of facts or opinions which have already been stated. For your information, the Wichita City Council has adopted a policy for all city zoning items. A copy of this policy is available in the lobby. The City Council relies on a written record of the Planning Commission hearings and does not conduct its own additional public hearings on these items. The decision of the BZA is final. Any appeal of a decision of the BZA is to district court.
At this time, I'd like to recess the Planning Commission meeting so that we might have our Board of Zoning Appeals meeting. We have no meeting minutes, so we will take the second item, BZA 2019-00038. Are there any people in the audience or any people on the commission that would like to hear this item? Is there anyone in the audience that would like to hear this item? Seeing none, do I have a motion?
Second.
Been moved by Mr. Hartman, second by Ms. Miles, to grant the variance. All those in favor of the motion say aye.
Aye.
All those opposed, nay. Motion carries unanimously. Bring back to order the Planning Commission meeting. First item on the agenda is the approval of minutes.
Second.
McKay moved to approve, second by Mr. Hartman. Any further discussion? Abstain. We have 2 abstentions, Mr. Blick and Mr. Richardson. All those in favor of the motion say aye.
Aye.
All those opposed, nay. Motion carries 9-0-2. Next, we will go through the subdivision committee recommendations. Item 2.1, I'm assuming we will hear. And we will take that item up at the end of the regular meeting. Next item is Subdivision 2019, number 37, one-step final plat for Waltz Second Edition at 13th and West Street. Are there any members of the committee that would like to hear this item? Any members in the audience? Seeing none, We'll take that on consent. Next item is subdivision 2019, number 39, one-step final plat for Sidro, third edition at Broadway and MacArthur. Anyone on the commission that would like to hear this item? Mr. Blick, we will hear this item. Next item, subdivision 2019-00040, one-step final, that was, Usidro fourth edition, located at West MacArthur Road in South Seneca. Anybody on the commission that would like to hear that item? Seeing none. Anyone in the audience? Seeing none, we'll take that on consent. Next case, 2019-0041, one-step final plat for German edition, basically at West 95th Street South and west of 119th Street West. Anyone on the commission that would like to hear this case? Anybody in the audience? Seeing none, we'll take this on consent. Item 2.6, subdivision 2019-00042, one-step final plat for Auburn Hills 17th edition, located at Kellogg and 135th Street West. Anybody on the commission that would like to hear this item? Mr. McKay will abstain. Anybody want to hear this? Anybody in the audience that would like to hear this? Seeing none, we'll take that on consent. Just a general reminder, we need to push our buttons on the microphone so that you can be heard.
I would like to make a motion 2.2, 2.4, 2.5. We'll make that separate because he abstained.
It's been moved by Mr. Johnson, and the second was Mr. Dool. Any other discussion on that? Hearing none. All those in favor of the motion signify by saying aye.
Aye.
All those opposed, nay. Motion carries 11-0.
I can make a motion on 2.6 to approve.
Second.
It's been moved by Mr. Johnson to approve item 2.6, and it was seconded by Ms. Miles. Any other discussion on this? Seeing none, all those in favor of the motion say aye.
Aye.
All those opposed, nay. And one abstention, so that motion carries 10-0-1.
You keep referencing 11. I believe there's 12 here.
There were 11 here.
I ran out of fingers, okay? We'll move on to the vacation items. Vacation item number 3.1, vacation 2019-00033. City vacation of 5-foot wall and 10-foot utility easement at 7922 West Meadow Park Court for a swimming pool. Anybody on the commission that would like to hear this item? Seeing none. Anybody in the audience that would like to hear this? Seeing none, we'll take that one on consent.
Move to approve item number 3.1.
Second. It was moved by Ms. Miles, second by Mr. Hartman to approve this item. All those in favor of the motion say aye.
Aye.
All those opposed, nay. Motion carries 12-0. Moving on to the public hearing. Item 4.1, conditional use 2019-00036 to allow vehicle and equipment sales at an outdoor area at Central and North Mays Road. Anybody on the commission that would like to hear this item? Seeing none. Anybody in the audience? Seeing none, we'll take that one on consent. Item 4.2, conditional use case 2019-00037 for an accessory apartment on land zoned rural residential at 71st Street South and 119th Street West. Anybody on the commission that would like to hear this case? Seeing none. Anybody in the audience? Seeing none, we'll take that one on consent. CUP 2019-0033, city minor amendment to CUP DP 267 to allow 6 duplexes per parcel on parcels 1, 6, and 7 in limited on North Tyler Road between on North Tyler Road and 37th Street North. Anybody on the commission that would like to hear that? Seeing none. Anybody in the audience? Seeing none, we'll take that one on consent. Zoning 2019-0033 and conditional 2019-0028. City zone change from B multifamily and general office to limited commercial to permit vehicle and equipment sales at Broadway and 13th. Anybody on the commission that would like to hear this?
I'd like to hear this case, please.
We will hear this case.
Mr. Chairman, I'll be abstaining from that item.
Item 4.5 has been deferred to December 19th, so we'll go to 4.6, which is zoning case 2019-0038. City zone change from single-family residential to neighborhood retail and limited commercial to allow commercial development on property located at 21st Street North and Oliver. Is there anybody on the commission we have too that would like to hear this? So we will hear this case.
Sorry. Motion to approve 4.1, 4.2, and 4.3.
Second. Been moved by Mr. Blick, second by Mr. Hartman to approve 4.1, 4.2, 4.3. All those in favor of the motion signify by saying aye.
Aye.
All those opposed, nay. Motion carries. Yes, Mr. Foster.
But they're gonna hear it.
We'll hear the Isidro Third Edition.
Neil Straw, planning staff, Cedro Third Edition. This property is located on the east side of Broadway, north of MacArthur. Property is by zone. The west portion is zone GC, east is LI. The LI portion was approved for conditional use for wrecking and salvage. At the subdivision committee last week, Public Works did not request any extensions. The site is currently served by water and sewer. Drainage plan was approved by city stormwater. Access controls were approved. There's one opening. one opening along Broadway. And we also had to approve a lot width to depth ratio per item F. Any questions for staff?
Do we have any questions for staff? Yes, Mr. Blick?
Question I have is, what type of surface are they required to have a wrecking salvage? Can they just go right in on grass and start stacking cars, or are they allowed to have some type of surface down below?
That's going to be subject to the site plan for the conditional use. Really was not portion of the plat review, so I don't have an answer for that.
By memory, I think they let them use crushed rock for that, but Knable's gonna double check here, it looks like.
There's nothing specific in the code regarding the surface, but as Neil mentioned, it would be part of the conditional use, so we could look that up and let you know.
That was just my concern, because I know that the property to the south is theirs also, and they just went right over grass. And so that's why I just had to question is if there is anything that's on there or not.
Technically, that wouldn't be a subdivision issue, so.
Was that the only issue that we had on that one? Okay, thank you, Neil. If we could have a motion then?
Move to approve.
Second.
Yeah, Mr. Johnson, you're right, but when we went through this, we only had one question. Was there anybody in the audience that wanted to address this one, just to be sure? Nope. Okay, thank you. Okay, so who made the motion? Richardson and Cindy. Richardson moved, Smiles second. Any other discussion, questions? Hearing none. All those in favor of the motion say aye.
Aye.
Aye. All those opposed, nay. Motion carries 11-01. Mr. Foster, was this the one that you were abstaining? Oh, 4-4s. Okay. I just don't want you to vote. Okay, 12-0. Okay, Mr. You're up.
Dave Yura with planning staff. Thank you, Mr. Chairman. This is a matter that's returned to the Planning Commission for reconsideration. You had previously approved the rezoning request, which was to initially request to rezone both lots, the one at 13th and Market at 215 East 13th Street, as well as the lot at 13th and Broadway, which is 221 East 13th. Request was to rezone those limited commercial. There was also a request for a conditional use to allow vehicle sales outdoor. The history on this is, many of you will recall, over a year ago, there was a request to just rezone the property at 13th and Market to GC. That got denied by the city council. There was not any indication to include the property at Broadway at that time. They subsequently came back and applied to both of them, requesting to go to LC with a conditional use for the car sales. The property at 13th and Broadway, and I can show some aerials, that has, there were at one time, wow, two houses on this property. One of them has been torn down. The other house that's at 215, kind of the eastern, most of the two houses has been remodeled, and the intent and desire is to allow this building to be used as the office for the vehicle sales activity that's occurring on the property to the east. You can see from the zoning map, there is a 1985 zoning case that granted in 1985 the car sales on that lot. At that time, in 1985, that property at 13th and Broadway was zoned LC. And I think it was early 2000s, when the Midtown plan was adopted, there was a downzoning that occurred. And at that time, the general office zoning was put on the property at 13th and Broadway, which made the car sales lot a nonconforming use. That continues to this day. This application was intended to bring that into compliance, as well as to allow the use of the property at 215 to be used in association with the car sales. The recommendation that went forward was to grant the zoning to LC and grant the conditional use for both lots, but to limit the use of the property, and this was the site plan, limit the use of property at 13th and Market to where this would not be allowed for vehicle display. It was going to be used for parking only. And that's what went forward to the city council. What we have now is that the applicant's agent made numerous discussions with city council representative. The DAB heard this, and their vote was 2-2, which officially meant they had no recommendation one way or the other on this. But the council has basically come to the conclusion, and the applicant has agreed, they will remove consideration of the change of zoning on the property at 221 East 13th from this rezone. Leave the zoning alone, leave the grandfather right there, which means they'll continue to be able to display and sell cars from that side. We will have to grant the zoning and conditional use on the property at 215 in order to be able to make car sales activity legitimate, because if, and the intent is, we understand it, that the operators want to adjust the license, and it will end up being granted by the state as a vehicle dealer's license at 215 East 13th. To do that, it has to be properly zoned. So even though there are no car sales or cars being displayed on this, for the office to be at 215, it has to be zoned. And so that's the modification to the request that was essentially being discussed by the city council. And they felt it was appropriate to buy time to get that back and send it back to the planning commission, so you were fully aware of what the substance was that was occurring. The end result, if this all goes through and gets approved, is that the property at 13th and Market would become zoned LC. It would have a conditional use for vehicle sales that will allow them to have the use of the office, but the conditions within the conditional use will restrict and say no vehicle display for vehicles for sale. That's only for parking. There are also some things they'll need to do, which would be, there will be some landscaping issues they'll have to work out along 13th Street, and they will need to modify the fence that's along the south lot line to meet the screening requirements of the zoning code. The current metal fence is not going to work, and they're aware of that and will make that modification. The property at 221 East 13th will remain zoned GO. This car sales lot will still be permitted as a grandfathered right. The idea, according to what we understand from the city council, is, and what they basically have, in response to objections from the Midtown area was basically to say, if the car sales activity at this location ever disappears, it will not be zoned to where it can come back. If they lose their grandfather right, then the car sales will not occur at that location, and there would not be any display of vehicles over at 13th and Market. That I hope I clarified what's really happening with this. And so what's before you today, as outlined in the new staff report, is that that's what is being understood as being done by the applicant. Now, Mr. Kaplan is here on behalf of the applicant and will be happy to further amplify that and clarify so you're aware that, yes, they are fully aware of what's happening here. And I hope I've explained that. I don't know if you want, I'm sure you've all seen, that's the existing operation at 13th and Broadway. As you can see, this is the house that was remodeled, and you can see there's the entrance off of 13th Street. That whole lot has been paved with concrete. That's another shot of the entire lot. You can see the fence in the background that does not meet the screening requirements. That will have to be changed to comply. That's a shot north along Market. I think that's north along Market. That's looking south along Market. And that's what's across the street to the west from essentially the lot at 215 13th Street. So be happy to answer any questions that you've got.
Do we have any questions? Yes, Mr. Hartman.
Dave, are they restricted on how many vehicles they can display for sale on that non-conforming lot?
At the one at 21st, at 13th and Market, or 13th and Broadway?
Yes.
Yeah, the BZA case from 1985 has conditions that place a maximum number of vehicles at 17, which is tough to get that many in there. And they also have a requirement to provide 4 parking spaces on that lot.
Okay, can you go back to the site plan? Now, it looks like there's parking spaces that overlap into the lot to the west.
Yeah, well, and then one of the conditions is to provide a new site plan was consistent with what would be approved. So this was submitted, and if this gets approved, it's going to have to be modified.
Okay.
Mr. Blick?
I just have a question and clarify in my head. So what you're saying is since they were grandfathered in all the way back, they had a car lot. And that's
on this lot, yeah.
On that lot right there. So to my knowledge, a couple of years back, that car lot, there was a car lot that was in it prior. They went away. Somebody else went in there, was selling car insurance, and then they closed down, and now this new car lot's in there. So in that time period, is there a time period that it goes back to originally what you're saying?
Well, since it's been grandfathered as of 2004, when the zoning changed, there are provisions within the zoning code that talk about when a use completely ceases, there is like up to a 12-month period, but it's an enforcement issue that's handled by another department. Dale?
We believe it to be a legal non-conforming use at this point in time.
Mr. Richardson?
So Dave, just to be clear, that site plan be revised, instead of saying vehicle display area, it's going to say
This
parking.
will say
on it.
parking only. It'll have to be adjusted so the parking stalls are on on the lot
Yeah.
the lot to the east.
And the dotted line there for vehicle display will remain as
Yeah.
the boundary, if you will.
Pretty much, yeah.
Yeah, thanks.
Any other questions? Okay, thank you. Dave, if we could have the agent or applicant, you could state your name, address, and you have 10 minutes.
Don't count my time in transit.
You now have 9, no.
Chairman, Commissioners, Bob Kaplan for the applicant. I have really nothing to add. That was a very thorough and very accurate presentation by Mr. Yearout, and he's covered it. I really can't add to that. I will tell you why the whole thing happened. It was mea culpa on the part of Bob Kaplan. I misunderstood the state licensing procedures. I thought the state licensed the site where the cars were situated and were sold. They do not. They license the site where the paperwork is done and the transaction is closed. And that's why I needed the commercial on the west lot that borders Market. And that was the only change. And I've had pretty much thorough discussions with everybody. I think everybody was on board with that. This commission passed it unanimously last time up. But the issue was mine because I didn't understand the licensing procedure. I do now, but I can take questions. But other than that, nothing to add. Dave covered it extremely well.
Do we have any questions for Mr. Kaplan? Thank you. Are there any members in the audience that would like to address this item? Okay, we'll bring it back to the commission.
I'd move for approval.
Second. It's been moved and seconded. Mr. Johnson made the motion and Mr. Florence second. Any other discussion? Mr. Blick?
Sorry, I apologize. Make sure that display area is changed with that motion on the site plan, as mentioned earlier.
It will be. Okay, all those in favor of the motion signify by saying aye.
Aye.
All those opposed, nay. Motion carries unanimously.
One abstention, Foster.
And this is the one that Foster was abstaining from, so it's 11:01. Actually, it'll be 10:01 because Mr. Dool is not in here. Philip, you're up.
Good afternoon, Commissioners. Philip Zievenbergen, Associate Planner with Planning Staff. Today we have before you a zoning change request to rezone a property near 21st and Oliver from single-family residential to limited commercial and neighborhood retail. The purpose of this rezone is to develop it for commercial uses. The applicant intends to rezone the east 2/3 of the property to limited commercial and the western 1/3 of the property to neighborhood retail. As you can see, and I mentioned before, it's basically at the corner of 21st and Oliver, about a block west of Oliver, north of the university. Currently, the site has a single-family home that is existing on there that was built in 1950 as part of the Crestview Lakes addition. The property to the east that abuts these two lots here have been subject to two separate rezoning attempts, one in 2013 and one in 2018. They were supposed to be heard concurrently today, but that, as we mentioned before in the meeting, was deferred until December 19th. Ultimately, those two zoning attempts were denied by City Council, but they still kind of have precedence today, as both those rezoning attempts were to provide some sort of commercial development on those lots and basically in this neighborhood. What's interesting is, as you look across the street on Oliver, there's large swaths of limited commercial zoning, but from Oliver to the west towards Hillside, there is no limited commercial zoning north of 21st Street. And so really paying attention to what has been going on in this corner in the past is very important to this site today, even though this site has not had a zone change request up to this point. As I mentioned, to the east is limited commercial, east of Oliver, even kind of to the southeast corner. You can see on the map that the surrounding vicinity around the residential lots is still single-family zoning with single-family homes on acres of or properties of at least 1 acre in size. Across the street on 21st Street to the south is the university's Innovation Campus. Directly across the street, the hotel that has been proposed for a while is slotted to open sometime in 2020. It used to be the Brayburn Golf Course on this map, and we can even go to the aerial. Not necessarily an updated aerial, but these two kind of parcel boundaries outlined is kind of that Brayburn commercials that were like the Shocker Store and Fuzzy's Tacos and all that is. And Starbucks are basically to the southwest of the subject site. The university is zone SFI, but it has the university overlay, which allows the university to accommodate their related uses anywhere from the commercial sites of the Brayburn area to student housing and anything basically to meet the university's needs, and the city really doesn't have jurisdiction over that. As I said before, there is no case history on this particular site. This is the first case for this site since this property has been developed in the 1950s. Other than that, overall though, there is some case history. After the 2018 rezoning attempt for this corner property here, the neighborhood worked with their city council person and got a neighborhood plan amendment adopted for the Northeast Heights neighborhood. The Northeast Heights neighborhood is from Oliver to Hillside, 21st Street to 29th Street. And that neighborhood amendment was specifically aimed at addressing possible redevelopment of the corner of 21st and Oliver, that northwest corner, from anything that's not residential. That plan amendment was adopted May of 2019, so it is still pretty fresh. And it outlines 5 specific policies that the neighborhood worked through to help guide possible non-residential development in this area. I'm going to briefly touch on those as they play a very key role into the determination in this case. The very first one says that every effort should be made to maintain the existing land use pattern located within this neighborhood. The second policy says that strip commercial development along Oliver and 21st Street is very discouraged, and that would be considered an invasive process if it does happen. The third policy gets a little bit more detailed, both with location and also architectural details. The plan amendment identified these 3 parcels here, these 3 lots, as the ones that would be acceptable for non-residential development. And if they were to be developed non-residentially, that the permitted uses should be limited to the general office zoning or something more restrictive. That any buildings should be have the same architectural character as the neighborhood around them. Building height would be limited to 35 feet. Window openings would not be allowed over 12 feet. That would face any residential properties. Monument signs would be limited to 8 feet, and lighting would be limited to 15 feet and obviously pointed away from any residential uses to avoid light pollution. Policy number 4 talks about buffering. Obviously, there'd be screening requirements per the code, which is with a masonry wall along any non-residential property boundaries or where they meet residential property boundaries. And it did stipulate that the landscaping requirement would have to be 1.5 times what is outlined in the code, with a 15-foot landscape buffer between the masonry wall and the uses that are commercial. And the 5th one is aimed to identify and help with drainage issues that are in the area. Through this public hearing process, there has been a lot of talk about the drainage issues that do exist, and it was basically making sure that a drainage plan was submitted and approved to the city that would not only meet the current needs of what that property would be going to. Obviously, if you're paving a lot more of the surface area, you're going to have a lot more runoff. Addressing that stormwater issue, but also potential issues that could arise in the future. The public facilities around there, 21st Street is 5-lane arterial, Oliver is a 4-lane arterial. I do need to make a correction. I stated that North Crestview Lakes Drive, which is kind of this circular drive this way. I have it stated that it's a 2-lane paved local street. It's actually just a single-lane local private road instead. So I was amiss in writing that, and that needs to be corrected. Related to the comprehensive plan, the comprehensive plan identifies this area as a mix of residential employment. So according to that, it could be conducive for non-residential development. However, the plan amendment that was adopted in 2019 kind of takes precedence and does not identify this particular lot as conducive for commercial development. It is with that staff is recommending full denial of this zoning request. However, we always have that caveat that if it is in your opinion as the Planning Commission to seek a rezoning, that we would recommend the GO as outlined in the plan amendment with a protective overlay that I'm not going to go into all the details. 99% of that protective overlay is just restating what's in those policies regarding development standards and landscaping and screening requirements, as well as several lists of uses that are accepted or basically not permitted on the site that would be allowed in GO. Do you have some site pictures? This is looking at the house that is on the property. We're looking due east from Crestview Drive. This is looking north along Crestview Drive. You can see here's one of the lakes and kind of landscape buffer that is in between the two versions of Crestview Drive. This is looking south towards 21st Street. You can see it's kind of a curvilinear street. I mean, it's pretty buffered from 21st Street, as you can see. This is across 21st Street, kind of from the Brayburn commercial area looking towards the site. You can see the house kind of nestled back in there with some significant landscaping along the street. This is from the corner of 21st and Oliver looking towards the university. You can see that commercial area that I was just previously standing at that has already been developed, and it's somewhere in this lot right here that hotel is slated to open later next year. This was heard at the DAB. It's further away. Oh, I apologize. This was heard at the DAB in October, on October 7th, and DAB agreed with staff recommendation, and they moved to deny any rezone of this property. And with that, I can stand for any questions.
Do we have any questions?
Vote was unanimous.
Unanimous to deny?
Yes.
Okay. Do you have any questions? Mr. Richardson?
Philip, the staff recommendation as an alternative is exactly the same as the restrictions on the staff recommendations as the one that was withdrawn. Is that
correct?
Correct. Okay.
We are handling both of these cases exactly the same.
Thanks.
Any other questions? Seeing none, if we could have the agent or applicant step up. You have 10 minutes, and if you could give us your name and your address.
Russ Avey, agent for the applicant with Boffman Company, 315 Ellis here in Wichita. Let's see if I can get back to... So as Philip mentioned, we did hear this several weeks ago at the District Advisory Board. We sped this case up a little bit and tried to hold back the case that has been filed on the hard corner to hear them in concert with one another. And I thought it was, albeit long, it was a very good conversation. It was a lot of information presented, a lot of discussion had that may not be reflected in that 10-0 vote to recommend denial, and I'll get onto that here in a minute. We weren't aware, frankly, that the other case was being deferred. There was a little bit of an indication from staff that maybe this case should be deferred as well. I thought, since we had members of the neighborhood here, since I obviously bothered to show up, that we'd go ahead and maybe get through some of these questions. Most of us in this room, with the exception of me, have been aware of these previous zoning cases spanning the last, 6-7 years. And so we understand the issues at play, but to note on that, we also understand that this issue of land use at this particular intersection is one that's probably not going to be solved without some sort of action to change the land use at this location. My applicants, my clients, happen to have been party to the opposition of the previous two cases. They happen to be party to the amendment to the comprehensive plan that helped form the foundation of this comprehensive plan amendment that staff mentioned. As such, nonetheless, being the property, one of several properties most directly impacted by any potential change in use, they were really motivated by what they saw happening with Wichita State across the street. Now, of course, it's SF5, and we can talk about the University Overlay District, but that's a commercial project. It is a large-scale commercial project, as is the northeast corner of this particular intersection. It's come to my attention that the southeast corner, the church, is also in play, perhaps seeking a zoning case here within the next year. So with the improvements that the city spent improving the function and capacity of this particular intersection, it's only natural that we're going to see a change in land uses benefiting directly from that investment. My clients have are taking jobs out of state, so they are putting their home up for sale. They were approached that perhaps there's an alternative to selling their home for residential use with the applications that keep cropping up year after year on the hard corner. They felt it was time to explore the opportunity of perhaps including this in one more or less unified, and I know it's two separate applications, but if you'll see the conditions that not only staff are recommending, but that we offered in our protective overlay, we are seeking cross-lot access to the hard corner lot. We're seeking complete access control to Crestview Lakes Drive. We want our project to support the project at the corner and vice versa. And quite frankly, understanding the nature of this particular piece of Wichita, we tried to make an application that was sensitive to the previous discussions, one that I think this commission and the city as a whole would have expected us to file with the split zoning of neighborhood retail and limited commercial and the protective overlay, embracing at least policies 3, 4, and 5 that was mentioned in the staff report. So again, not looking at necessarily what has happened in the past, but looking with an eye toward the future, we felt that we would at least begin the discussion of changing the zoning on my applicant's property with something that we would see as reasonable. During the District Advisory Board meeting, there was quite a bit of discussion about residential, large lot residential development, old historic residential development at the arterial corner. A much less intensive arterial corner is 13th and Woodlawn that has a home sitting on the northwest corner. And I drive by it all the time. It's not getting any better. It is perhaps becoming a blight on that particular neighborhood. And it's a pretty good example. They were using it as an example of why you can just simply have residential butting right up to an arterial intersection. I would argue the contrary. And we've also had residential hard corners, I'm going to say Ridge Road and Maple, where we had residents right up against the arterial intersection. We had policy after policy of a hard no to any non-residential development. And now we have the Ridge 400 development, which has functioned and interacted with that neighborhood to the east quite well. So this has been done. I think we've seen it done numerous times. I think the application that we filed is sensitive to the neighborhood's concerns. And I will stand for any questions that you may have of me at this point.
Thank you. Do we have any questions? Yes, Mr. Hartman?
Russ, do you know what the access control is along that property? And how wide is it along 21st Street?
Along 21st Street, we are just approximately 300 feet. So we'd have about 600 feet from the intersection to Crestview Lakes, more or less.
And do you know what the access control is there?
There is none. But if I may just add, Mr. Hartman, to your question, there is a new stormwater inlet that's approximately at that division line. We would expect one opening onto 21st Street. In the past, this property was limited to a right-in, right-out only, which now functions as a right-in, right-out only due to the improvements, the raised median at 21st Street. So there would be plenty of capacity with turn lanes into the property, into our property. We have asked staff to ensure that we are offering cross-lot access to help this function in the most efficient manner from a traffic standpoint.
Russ, I'm assuming that the items for the protective overlay that the District Advisory Board saw were the ones that are on the handout that we received, not from you, but the staff report. Is that correct?
That is correct. Mm-hmm.
So they have not seen the additional allowances that you have made for your overlay that we received today, then, I guess.
I will describe it as this. So we filed we filed our application with protective overlay. Staff came back with a number of comments directly related to how the comprehensive plan amendments policies lay out additional restrictions. We were off slightly on a few things. A few things were needed to be reworded. So from that standpoint, we modified it. We filed it with the protective overlay dated the 29th of September. This was the 30th of September. I don't believe our protective overlay probably got out to the District Advisory Board. I will state for the record that it certainly didn't matter one way or the other. So from that standpoint, what we had provided was in general harmony with what staff was recommending as conditions of approval for the hard corner for those two lots to the east. As a matter of policy and as a matter of this comprehensive plan amendment, clearly we weren't going to nor expecting staff support as far as our request goes. There again, as I mentioned at the start, we felt that in spite of policies, in spite of everything that's happened in the past, this is a reasonable request. One of the things the District Advisory Board did discuss was kind of the no man's land, this general office. So I think you're going to hear, and I don't want to speak for the neighborhood, but you're going to hear a general disagreement with any change, and that's understandable. We were obviously, both applicants were asking for commercial zoning with various limitations on these protective overlays. General office really just kind of got overshot, right? So I don't think anybody in the comprehensive plan recommends nothing greater than office, and nobody in that room really was supportive of office. There were 4 or 5 members of the District Advisory Board that saw the merits in this having a change of use. I don't think anybody in that room really thought general office was the best idea. I think there was an expectation that it would feel good, perhaps, to approve something like general office. With the expectation that probably when it sets vacant for the next 5 years, you're going to see this application come back around, so.
Because that was going to be my next question, if general office that was the alternative that we have in the staff report, if we were to deny but approve something, so.
You know, clearly, at District Advisory Board, time for questions and answers was over with by the time I got up to bat, to be perfectly honest. I just answered a few minor site questions and drainage questions and things of that nature and put my 2 cents in there. But the Marks case had gone previous. Most of the discussion that was relevant for them was relevant for us. And so there was really very little hashing by the time I was able to get to the podium. But clearly, we're seeking what we're seeking, and we feel like we put in a pretty good request. If the Planning Commission, having more knowledge about this particular intersection than I do, feels it necessary to approve it per staff's supplementary recommendation, then we would accept that.
Mr. Richardson.
Russ, this is a question which may or may not have any bearing on this, but if you look at GIS, the whole private street thing and the lakes there appear to be owned by the city. Doesn't show a homeowners association owning it. Is that in a homeowners association?
I will let them answer. The lakes are owned on a pro rata share basis by every owner. So, you know, if there's 10 lots in there, my client owns 1/10 of those lakes in that street. It's just kind of whatever they did in the 40s, right? So I don't know if it's a deed if it's in the deed or what, but if you look at the ownership list, you'll notice, similar to a condominium association, they own a percentage share or a part share in all of the open space, lakes, and roads, I believe is how it's stated.
Yeah, if you look at the plat, the property line goes from the street all the way back to that north lake there. So it looks
Certainly.
like the city would own it, but there are probably other documents somewhere that.
Usually you don't expect private streets to show up in GIS, and I could be completely wrong about that.
But the lakes, the whole thing is like no ownership found. That's why I was
Certainly.
wondering.
I would think of it, I think of it wrong, right, wrong, or indifferent, similar to a condominium association where you own a fractional share of all of it, of all of the open space, lakes, and roads. And I would like to comment that our application width east to west is probably more like 350.
Any other questions? Seeing none, we'll open it up to the public. Is there anybody in the audience that would like to address this? If you could state your name and address, and you have 3 minutes to present your case.
Excellent. Hi there. I'm Christina Unrein. I'm at 7 Crestview Lakes Estates. So I live over here. I have no good news for you. We're against this. And I know a lot of you want things to commercially happen there. And we appreciate that this developer actually gives a crap, right? Like we're on the up and up with at least quality people working there. We're still against it. Let me give you the reasons we're against it. First of all, the community plan we made, including the neighbors that want this rezoned, was agreed that all of this needs to remain single-family residential. And there's a reason, because if we start going down one side of the road or the other, there's no place that it stops. Everybody next to them gets to justify it again and again and again, and the neighbor right above them now has it on 2 sides of them, instead of just whatever goes in their backyard if that ever gets rezoned. Also, they're happily moving out of state for a job. And because they're moving, now they decide, oh, we'd like to get a lot of money for this, because they care about us so much. And then on top of that, they haven't even listed it for sale as a residence. You saw it. It's a nice residence. It's blocked off from the street. And it does own 1/16 of all of the private property, the roads, the lakes. We all have to take care of that. And we need the funds to take care of that on an annual basis in perpetuity. They also committed and signed in 2016 our restrictive covenants that requires all of the lots to remain single-family residential. They signed it, both of them did. And the plan, they tell you that they're being very kind to us and understanding of us. The plan itself says that GO is the highest use, even for the corner. You have LC here. That's not being kind to us. That's not working with us. That's overstepping. So if you're worried that, we're just being those not in our backyard type of neighbors, that's not what this is about. I realize a site plan is not required in the city of Wichita like it is in other places. But if somebody brought to us and worked with us to come up with a plan that's a site plan that is what is actually going to happen, we might be open to it. The problem is, as soon as we sign this over and we give it rights to be whatever they want it to be, they can put anything there, and we have no say after that. And what they restricted themselves to is limited commercial. They want it to be maybe a restaurant with a drive-through. Does not sound very residential, does not sound very walkable. The only other thing I want to say is we're against this, but if you do decide to rezone it, please, GO is the highest we wanted, and that was for the corner stuff. Consider something like neighborhood office or something less, but really, we would like it to remain residential. Any questions?
Yes, thank you. Your time is up. The only question I have is, so you would agree to general office zoning since that's what you're...
No.
Well,
for them, I would not agree to general office. In the 3 lots in the plan, we were as a community, we worked on that for like 8 months to a year. We decided that general office was the highest that we would give to the appropriate location right here. And that's what we decided for those. And this is not part of that. So I'm saying it should not even be at that level because it's even more intrusive into our neighborhood than the stuff that's off into the corner and with lots of traffic. So no, GO is not okay with me.
Okay.
Any other questions?
Yes, Mr. Richardson?
I have a question about, you indicated that the neighbors all signed restrictive covenants. Were those filed of record as a restrictive covenant?
Definitely.
You
want a copy?
Well, no, I don't really want a copy, but it changes. And how are those restrictive covenants changed then? If someone wants to change their lot, does everyone have to vote on it?
So because we have joint property, we have a homeowners association. And the homeowners association is how we make decisions, but each lot owner or multiple owners has to sign off. So for the extension agreement of our previous covenants that we had signed in March of 2016 and registered with the deed, the Register of Deeds, they signed off. Both Kate and Byron Nilsson signed off, and we got a majority of everybody in order to maintain those covenants.
Well, my question would be then, according to the covenants, assuming these people signed, which you said they did, I'm going to ask for some legal help here.
Please.
Looks like that would trump the zoning here if it restricts it to residential use.
Well, as you know, private covenants would be a private action that the rest of the people that are party to the covenants would have to then hire a lawyer and basically sue the folks that are violating. The Planning Commission and the City Council are free to approve a zone change request. Whether or not they could actually ever use it or not is dependent on the outcome of whatever legal action would happen after that.
Yeah, does that make sense to you, what he was saying?
Yes, so we know if you guys rezone it, we have to, with the 16 people we have and the money we have to gather it all together and we have to uphold our covenants and go the legal route. We understand that.
Thank you.
Mr. McKay?
I don't know about their homeowners association, but most homeowners association has a percentage of approval by the balance of the deal to make a change. In other words, if somebody wants to make a change, it says like 75% of the people must agree to it or whatever that might be. That's normally how homeowners associations work.
So just for clarification, the general office where was that discussion? Is that a part of your restrictive covenants? Or is that just something that the neighborhood decided that the maximum that you would allow for the corner lots to be general office? Where does that general office come into play
He can tell you, and so can Dale.
From the homeowners association?
That was what was approved by the amendment to the neighborhood plan, or to the comprehensive plan. The language in the plan amendment suggests, like Philip read, that if you're going to do something more intense than residential, that is the most intense that you should consider, I think.
But that's not a part of the restrictive covenants that you've got there. That was my question. I understand the rest. I just didn't know if it was in your restrictive covenants.
No, our restrictive covenants are for single family.
Mr. Hartman, you have a question?
I have a question. I don't know if you can answer this, but if that property is sold and it goes to a different zoning classification, would they still be responsible for helping you maintain that road and those lakes?
So that's where it becomes difficult, because according to the restrictive covenants, nobody has rights to our lakes or any of the joint owned property, which we all have 1/16 of the property deeded on our deed with our house. We all have that. They would no longer have access to that, but somehow they have to keep paying for it. So we're going to have to probably do legal action that way too, to find out, can we give it back to the homeowners? Do we the association? Do we give it back to ourselves? How do we do that? It'll be more legal stuff in order to not have non-residential uses happening in the residential only areas.
So if they were taken out of the association, that would mean that you have less owners that would have to
Yes.
pay and maintain all your roads, which would be a pretty good burden on.
Yeah, because there's 16 total of us, and with the other one that dropped out today or got deferred, we're talking 3 of the 16 that need to help pay for things are going to disappear, and we're going to have to up that burden.
Mr. Hartman and then Mr. Dool. Mr. Richardson and then Mr. Dool.
So the lots that were, in the case that was deferred, they also signed and are party to these restrictive covenants?
They did not sign them. We had a majority of all the lot owners of 16 that signed them and put them into the deed.
Okay, thank you.
Yep.
Yes, Mr. Dool. Remember to push a button.
You just asked my question.
Yeah, so this lot did sign them. The other 2 did not sign them.
So
The
The
two
one
corner
that's
lots.
right here, the one we're currently talking about, they signed the restrictive covenants to maintain it in perpetuity as residential. The 2 that got deferred, they did not, but we had a majority, like he said, we had a majority in order to get the deed.
Mr. Blick.
So when you said majority, is that the rest of all the other 16 have signed, or was there any others that did not sign?
Was it 13? We can't find number 13, but everybody else signed. So this lot, we cannot find the owner, and we haven't for years. So everybody else in the entire community signed, except for the person we can't find and the 2 on the corner.
Okay, if we could have the next speaker, if there's anybody else, thank you.
Thank you.
Again, please state your name and address for the record. You have 3 minutes and try to refrain from repeating what was previously said.
Okay, my name is Craig Tolson, and I am at 4 Crestview Lakes, which is this piece of property. I am located here. And some of the questions came up today that I was going to ask this board. It sounds like you guys have already said that the neighborhood needed, or the GO was what you guys approved for us. I've got questions. What were your thoughts on this LC, or did you have time to consider this? I received the LC notice, or at least request, at 4 o'clock this morning. So I haven't had time to evaluate any of this, but I assume that you guys have had it in your hands prior to this.
Just a point of clarification, Mr. Tolson, nothing has changed on the zoning at this time. It has not been changed to GO, it has not been changed to limited to commercial. It's still zoned the way it has been.
Yes, okay, understood. I was just, again, trying to get feedback of you guys' opinion of an LC versus a city.
Once all the testimony is in, then the planning commission will close the public hearing and they'll make whatever comments they're gonna make. That's in order to comply with legal requirements.
Okay.
They're not supposed to make any opinions till they've heard everybody's comments.
Yes, sir. Very good. Has there been any other divided properties? One property divided into 2 zones for something like this?
Yes, that's happened in the past, and yeah, that's not that unusual.
Not that unusual, okay. I guess, okay, I'll continue. If that 1/16 is correct for all three of these properties, or even the three that, this one is, okay, and these other two, if that is stated on their, I don't know, I'm at a loss for words. If that is stated on their deeds, are they still responsible even though they claim that they don't want to be part of the association?
That's a legal matter that would have to be sorted out between attorneys that would represent the neighborhood and whoever is saying that they're not subject to your covenants. It's not really something the city is involved with. It's not a party to your covenants, and so it's not really appropriate for us to comment on that.
Okay. I'm sorry? Yeah, well, again, I'm concerned that, like I said, like you guys have said, or this gentleman has said, Russ, that if LC is established, even with protective covenants, that whatever is allowed there happens to fail, because we've looked at this neighborhood with LCs for years.
Mr. Tolson, your time is up, and I know that we have paused when we have asked questions and then started the time back up. Do you need another minute to finish your thoughts?
Just one or two. I need to put these questions in front of you. Just a minute or so, please.
Okay, we'll give you one more minute.
Yes, sir. Entrance and exit protections. If this changes, how does this piece of property and the ownership of the lakes, as was stated earlier, how are we assisted in that? If new owners take it. And what kind of runoff preparations for a split property like this?
With respect to drainage, they would have to submit a new drainage plan with any building permit plans if the zoning is changed. How they would interact with your maintenance of the private road and those covenants, that's again another a private issue that would be between the homeowners association and those that are a party to it.
And at this point, they have complete access control on Crestview Lakes Road. The only access that they would have from this property would be onto 21st Street.
So I understand that if the zoning changes, they still have complete access?
They would have to submit it in a manner that would say that there would be complete access control on Crestview Lakes Road, which would mean they could not enter or exit onto Crestview Lakes Road. It would only be onto 21st Street.
Thank you. Any questions?
Do we have any questions for the speaker? Yes, Ms. Gross.
Is your biggest concern the financial burden, having these lots pull out on your covenants, or are you at all concerned?
Well, that is one of the concerns, yes. But LC is so far above the NO that, or general office, that it frightens us. As I've stated, I am now abutted on two sides with something that's looks ridiculous to me.
So would you be opposed to any other besides residential on those corner lots or on that lot that we're looking at right now?
Well, what we were trying to do, like I said, the general office is, I believe it was banks or something with a lot less possibility of intrusion. You know, it's a private residence. I don't know how you would feel about it, but I'm not thrilled to have, you know, what's allowed under LC or a lot of the things under LC. And again, I received the proposal this morning at 4:30 and didn't really get to it until 8 to start looking at what was proposed by
Thank you.
Nielsen's.
Thank you.
Thank you.
If we could have anybody else that would like to address this?
Hi, my name is Julia Falke. I'm at 3 Crestview Lakes Estates. From sitting in the audience listening to this stuff, it feels like things are getting really blurred because we're supposed to be talking about number 2, and there's a tremendous amount of discussion about the 2 properties or the 3 properties along Oliver. And that's really concerning to me because it's very confusing to people. It's sad that we're not doing all of them today, that the one at 11 and 12 pulled out, and that we're still hearing this one, but that's the way it is. This is a really huge, maybe you guys don't know that this perpetrates a financial burden on all of us, because every time any of these things come up that are in our neighborhood, we have to take off work. We make arrangements to go to all kinds of different meetings. We have applicants that make arrangements to speak at meetings. Everybody goes, and then they don't show up. We come here, everybody was prepared to come here, and the applicant, we get the email this morning that the applicant over on Oliver has pulled out. The fact that if we do end up with zoning changes on those properties, that then it does make a financial burden on us because, number one, we have to figure out how we're going to enforce our restrictive covenants and protections. That takes money. We've got 16 properties in this commonly held area, and we don't have really high yearly assessments because, honestly, most of us that live there couldn't pay the yearly assessments that they have in some of the homeowners associations out east. And so this is a really big deal to us. Everybody says, well, it's just a private thing and you'll just have to deal with it legally. And that is the truth, and we understand that. But our pockets are not hugely deep, and this is not anything that is news to the folks that are trying to do their zoning changes. It is disappointing that Kate and Byron, that the Nielsens have filed for this, because one of the things that we did when we tried to do the neighborhood plan to go into the master plan was we were trying to, as a community, not just Crestview Lakes, so don't get that into your heads that it's just our little 16 or 13 houses that are in charge of this. This was that whole big area of the Northeast neighborhood. And we're trying to understand that we may not have a choice, that it may turn to a higher use at some point, but what is best for the community? How can a plan help guide planning, help guide you guys, help guide the city council to make appropriate choices? So we've gone through all of that, again, a financial hardship because people are taking time, people are taking off work.
Ma'am?
And yes, sir.
Your time has run
Can I have
out.
1 minute?
Would you like one more minute?
I would like a minute.
Absolutely, if you can wrap it up.
Okay. And the fact that then, after we've gone through all of that work, yes, they come in and people make their application with something well and above what the neighborhood worked on, including Kate and Byron worked on. So it's insulting to me personally that we have to keep coming back to this, and you guys probably get sick of hearing us all the time on this. So for me, for this parcel, because that's all we're talking about right now, is please deny it. It's the cancer that we talked to. It's the cancer that we told you once things started happening and changing, it was likely to start going down both roads. And that's what we need to have stopped. So please vote against it. And then I don't know how we do it, but it would be great if we could figure out how to defer the one that is on number 11 and 12 to after Christmas, because that is a hardship on us now, because we'll be doing a lot of footwork right during Christmas. So I'm just going to put that out there for you, and thank you for your time, and I will answer any questions.
Do we have any questions for the speaker? Seeing none, thank you very much.
Thank you for your time.
If we could have the next speaker, you have 3 minutes. If you could state your name and address.
Yes,
for
my
the
name is
record.
Charlie Rivera.
And if you could limit your comments to those that we haven't heard yet today.
Okay. I got one of them New York accents. They travel across the room. My name is Charlie Rivera. I'm the president of the Willow Lake Association, which is everything north of the area we're talking about, back in here. That's my lake.
Sir, if you could use the mouse at the podium.
Okay, so
we
it's
can't.
everything north of this area that we're talking about here. We have 31 homes. And regarding all the questions you had a moment ago regarding homeowner association, we're going through it too. One of my most biggest concerns, first of all, yes, we are against that breaking down there, changing the ruling there. We are very concerned about you doing this because after all our covenants that we work so hard to enforce, I have 31 homes and we use these funds to keep the lake up, to keep up the whole area, which goes all the way to 25th Street. The domino effect Carol's talking about, believe me, I was here at this table right here just a year ago, and we were concerned about what happened here continuing to go down. Once you hit this point here, I have 7 homes in my association that are on Oliver, and every one of them wants to know when can they turn around and make their property like commercial and start developing multi-home complexes along there. Because they realize if this domino is going this way, it's sure as heck going to go up on Oliver. We're terribly concerned about that. As Carol says, we don't have the resources to legally take on some of these guys. We got beat up by the Marxists, if I may allow to say that. I personally got beat up by the Marxists because they have property in my area there, the 31 homes that I'm up here, and believe me, they have been not the best neighbors. And then the last final comment I wanted to make is that we went through a lot of work doing this overlay that we just did through the DAP, which was designed to try to protect the integrity of this community, which is everything along 21st between Oliver and Hillside going back up to 29th. And the idea was, let's not allow this domino effect. Let's not allow some of this zoning. We have been contacted by realtors in our area up here wondering if we are interested in selling our homes along the lake for what else? So they could buy my lot, which is right here, an acre lot, and easily put in a duplex in there if they can get like commercial zoning or whatever else they need. Please protect the integrity of this community. Crestview is a lovely community. Welcome anybody to drive down that block, that little loop of theirs. The homes are great. Everything is kept up. And like she says, they've lost 3 already that are not going to be paying dues. I know the effect of having 31 homes and only 26 of them paying dues, help maintain the area. Thank you for your time. I'm sure you'll make the best decision. I said, Lee.
Thank you, Mr. Rivera. Are there any questions? Seeing none, if we could have the next speaker, you have 3 minutes, and if you could state your name and address, please.
Arthur D. Hart. I live at 1 Crestview Lakes, and 1, I'm trying to find is there an error on there it is. That's 1 Crestview Lakes. I've lived at that property for 37 years. I have basically nothing to add beyond what has already been spoken, and I plead with you also to vote no. The history of that area is well known to me. I raised 3 children there. I've watched continuously traffic pick up. I thank God that none of my kids were injured. I have had pets hit. I've done several other things, but that's not common only to that neighborhood. I would tell you that we have endured a lot to help maintain a neighborhood that this city could be proud of. I know that you've been to other cities. You see areas where there are neighborhoods that are green, that are open, that are nice. They've appealed and make the community a better community. If we take and start breaking up our community of his 31, our 16, now 13, we will be in terrible shape. Go to Kansas City and look around Kansas City and how those pristine neighborhoods make it a better city. Look at Wichita. How many places in this city do you have where people can actually live on acre-and-a-half lots and together sacrifice what it takes to make that property a good community in this city? Please do not take that away. The golf course was beautiful. They had a different plan. That plan, we've all accepted that. We understand it as progress, but we do not need to have our homes destroyed. We don't have the money that it takes to fight, I hate to say it, City Hall. But I would say to you, and I know you have you have a comparison of your own in your own neighborhood, do not destroy what has been around for now more than 70 years. I have a daughter that would like to move back from California and have that home someday. And I would love to be able to leave that in my will. I'm being personal and perhaps selfish, but I think if you would relate to that in your own brain, you would see why I'm here and very passionate about the fact that Crestview Lakes and the Northeast area need to be maintained. We're good neighbors for the university. We're good neighbors for the surrounding community. We don't need anything more. That corner is big. It's going to attract a lot of development. Don't develop our neighborhood. Our neighborhood needs to stay intact. And I know that you guys have heard these things before, but you've heard it from a guy that's been there almost 40 years. And the changes we've endured have been very painful, and one more would be even more painful. Thank you very much. Are there
Thank you, Mr. Dehart. Are there any questions? Seeing none, thank you very much.
Thank you.
Are there any other speakers that wish to address this item? If not, if you could state your name and address for the record, and if you could limit your comments to those that we haven't already heard. Thank you.
Brenda Stevenson, 4723 East 27th Street. And I'm a member of the Northeast Heights Neighborhood Association, which this, I just want to point out why the comprehensive plan for rezoning happened. It's because all of this area clear down for 40 years is failed business attempts, leaving blight behind. And also, this plan was passed because of the water issues regarding lakes and tributaries being used as stormwater drainage. There are a lot of small shops that they come and they go on both sides, pointing out that this section has never supported business. Right now, right here, this northeast corner, a section of this commercial building has been torn down and apartments are being built. Also, the WSU campus over here is struggling with obtaining businesses to build there. The other issue about this entire area is the fact that Oliver and 21st area is blocked off by K96 graveyards, Large City Park, and WSU. So we want WSU to succeed. And the other thing I see is that changing this zoning here is quite invasive to the neighborhood. And actually, I live a whole mile down at 28th Street, down by the Metroplex for WSU. And it even affects all of us. Any questions?
Thank you, Ms. Stevenson. Any questions for the speaker? Seeing none, thank you very much. Is there anybody else that would like to speak? If we could have your name and address for the record, you have 3 minutes.
Scott Langenberg, number 5, Crestview Lakes. This is my property. The city contributed to this issue by developing this corner for WSU. They made 2 turn lanes in all directions. Hillside does not have that. 21st and Woodlawn does not have that. 21st and Rock does not have that. Think about it. Now, that is why this is before us. We've already talked about these 3 properties over here. The question before us right now is this property. I would strongly encourage you to turn down this application for the simple fact that we want to keep all the properties around the lake intact, as well as the Greater Northeast Heights Neighborhood Association, the square mile, as we call it. I also wanted to point out that at this time is no development here on this corner. Whoops. How do I go back? There we go. No development on this corner right now at WSU.